in fact, are really of no value. The KPMG withdrew its conclusions. KPMG claimed that he did a documentary analysis only. And KPMG said that it can, to the extent that there's anything in the report that pertains to discussions about the law, or etc., or interpretation of the law, they are not qualified to do that. And KPMG withdrew its conclusion. And I think one of the judgments that we're dealing with actually says KPMG is wrong in fact and in law.
Yeah, no, we'll get there, Mr. Pillay. I'm just, remember that's all this, and then the IGI report was reviewed and set aside and all that. I'm just talking about at the time, just work with me here. So we will get to what then became of those findings. But I'm simply saying to you that the fourth independent agency at the time that found the unit to be lawful was KPMG, correct?
Well, I would question the word independent.
Okay, let's say external.
Can I make the point that I would say that all of these institutions or bodies were connected to each other in some way.
Okay, including the one, I'm sorry, Mr. Pillay.
In advancing the same narrative.
Yes, including the one that you appointed.
Indeed.
So why did you appoint people? Sorry, carry on.
I appointed Advocate Skakane to investigate allegations around Johan van Lockelenberg.
Yes.
And that was the terms of reference. And if I understand it now, it was a fact-finding request.
Okay.
But what actually happened is that Advocate Skakane decided to change the terms of reference on his own. And it actually coincides with the Sunday Times barrage of reports. And it coincides with the appointment of the new commissioner of SARS. And my understanding is that the Skakane report is an opinion, and I responded in a critique of that document, a 32-page critique, which the then commissioner of SARS refused to read. The critique is there, and I made it available to the public protector also. So we were told by legal counsel that there's no point in trying to set aside that report because it's just an opinion.
Yes, no, that's I understand that. You do accept also that the judgments that you've been reading are also opinions?
No, I don't accept that. Look, I'm not a lawyer.
Yes.
And actually, I'm not a qualified person so I can't argue from legal point of these things. But for me, my understanding, the judgment stands, and it's final. And if there are issues with any of the judgments, they must be dealt with within the judiciary process. And that is my view. It cannot be a mere opinion. That does not mean that a judgment cannot be contextualized, etc. For sure, all of that can be done. but I regard it as binding between myself and the public protector.
I see. So you regard it as binding, even if it is still going to be finalized by the Constitutional Court?
My understanding, and as I understood an interaction between you and one of the other persons like yourself who provided evidence, is that the judgment stands until the judgment is set aside. And my understanding here is that there's an application for leave to appeal. Once, if the leave is granted, then an appeal would be made, and then there might be a judgment that's 2 or 4. And until then, the present judgment stands.
Okay, all right. No, okay, no, it's fine. You are wrong about that. The application for leave to appeal is what suspends the judgment. But as I say, we don't want to get into legalities. Your opinion is that the judgment, irrespective of the fact that it might be reversed, it's final or whatever. Am I capturing your understanding correctly?
What I'm saying is that the first matter is final, the way I understand it, which is the matter around the pension issue and my re-employment. Mm-hmm. The second matter, there is a judgment, and leave to appeal was refused, and the matter all up the chain, and the matter is now before Constitutional Court for leave to appeal.
Right. So
what we do have now is a binding judgment. Until that is set aside,
yeah, okay. No, all right, fine. I won't bore you with the legalities. Let me just say, that's a wrong understanding of the situation. All right. And you're saying you don't know that a judgment, even if it has been, even the one that where there's been a final judgment of the Constitutional Court, that it constitutes an opinion?
No. Well, for me, as I say, I'm not a lawyer. I've always regarded that there are 3 arms, 3 spheres of government, and independent spheres of government, and these matters were decided in court, and that's where they stand.
Okay.
That's my view. It may not be the right view, the correct view, but I don't pretend to be a lawyer on the matter.
No, fine. No, I promise you that's not what I'm doing. I'm just surprised because this is in a judgment that is about you. This whole thing, the one that you've been reading copiously here. Can we go to that, the judgment of Godan, Mahashula Pillay, and Office of the Public Protector? That's the 36099. If is the one that Mr. Pillay was reading out.
Okay, you got that, Tsepo? We're looking for it, Advocate Mpofu.
Thank you, Chair.
We'll flight it immediately.
Yes, and when we find it, please go to roundabout paragraph 95.
95.
Yes. And anyway, while we are waiting, Mr. Pillay, do you remember that both you and Mr. Godan were trying to do what some of the members want this committee to do, which is to rely directly on court judgments in order to get personal costs against the public protector? Remember that?
Yes.
And the court rejected your attempt to get personal costs against the public protector, correct?
On that occasion?
Yes, we're talking about that occasion, yeah. Yes, and one of the grounds was what you and I are debating now, correct? Oh, you might not remember, okay, then maybe you just read the parts that you were asked to read. But if you read the whole judgment, can you go to paragraph 95? Rather, I'm sorry, start at paragraph 91.
Okay, we'll go there.
90.
Oh, you keep changing. Okay, we'll go with you as you change.
Yeah, don't tempt me, Chairperson. Otherwise,
we are there now.
We'll go to 80 now. If you, no, I'm joking. All right, now let's leave it here at 90. Okay, I'll read it out just to make it fast, if you don't mind, Mr. Pillay.
For you, Chair. Fine.
Yeah. Now, okay, firstly, before I do that, you remember that you had fully associated yourself with the allegations made by Minister Godan in the relevant portions, including asking for personal costs, correct?
Correct.
And for that, the court punished you with a punitive cost on the attorney and client scale, correct?
Correct.
Okay. Also, because you had made gratuitous insults against the public protector, correct? Correct?
I think you must point that out to me. Wait.
Okay, I'll do that. Okay, let's start with this one. It says in 90, in paragraph 53 to 55 of the founding affidavit, Minister Godan, which you associated yourself with, directly quotes portions of judgments where adverse findings were made in respect of the public protector. I do not intend to quote them here, as they are succinctly set out in Minister Godan's founding affidavit. It is alleged that those paragraphs specifically reference instances of repeated admonishments that the public protector received from the courts to comply with the Constitution and the Public Protector Act, and where she was mulcted with personal costs as a result of her failure. Paragraph 91, relying on National Director of Public Prosecutions, that's a case in the Supreme Court of Appeal, the public protector in her heads of argument submits that the allegations relating to other court cases ought to be struck out as irrelevant, as they constitute the opinions of other courts, and the decision of which some are still pending. The thing that you and I have just debated. So the applicants, on the other hand, submits that the judgments are directly relevant, as some in this committee do, to this review, and also have a bearing on the order of personal costs and so on and so on. And then if you can go to 95, just jump to 95. Yeah. And then it says, the court in Institute for Accountability in Southern Africa, that's another case we presented to the court, of the Gauteng court, when determining whether the Hollington rule applied in relation to the applicability of findings of previous courts to subsequent civil proceedings, held as follows. Ultimately, the rationale for a Hollington rule is that the findings of previous court constitutes the opinion of that court, and for that reason, irrelevant and inadmissible in subsequent civil proceedings. Even though such findings constitute expressions of opinion, they cannot be equated with the opinions of ordinary individuals and not be treated as such. Those findings were made by judges and confirmed in certain circumstances by justices of the High Court. Judges have a duty to form and express opinions concerning issues raised before them, and so on. The opinions are also binding on all persons on whose organs of state in which they apply. And then just, yeah, so for all these reasons, the impugned paragraphs must be struck out as irrelevant. In other words, your attempt to get the court to rely on previous judgment was, sorry, can you see me? Because I can't see myself.
No, can't see you.
Okay, let me try. Okay, there you are. Sorry, Mr. Pillay. I was saying, do you accept that your attempt to use previous judgments to rely on, in order to criticize the public protector, were rejected by the court on the basis that those were opinions of those courts? Correct?
My understanding is that the court view was that it was not relevant to what was before the court.
Yes, but it was not relevant because it was opinions of the courts. I've just read it out to you, correct?
Through you, Chair, I don't want to get into a legal argument because I say I'm not a legal person. I thought the issue was not that it's just an opinion, but it's the relevance.
Yes, that's the. Believe me, Mr. Pillay, I'm trying to simplify it as much as possible. I don't expect you to know the law, but at least just to have an ear to listen to what I'm saying. I'm saying I read out to you, so the public protector submit the allegations relating to other courts ought to be struck out as irrelevant as they constitute the opinions of other courts. So it's exactly the same point. They're not just irrelevant in the air. She was saying they are irrelevant as they constitute the opinions of the courts, the decisions of which some are still pending. The court agreed with her. So for all these reasons, the impugned paragraphs must be struck out as irrelevant for those reasons. I mean, you don't need to be a lawyer to understand. That's just, I'm reading it out for you.
Yeah, it says the impugned paragraphs must be struck out as irrelevant.
Yes, but the basis upon which they were said to be relevant was because there were opinions of other courts, including the Hollington rule. I don't want to get into detail, the one that I just read out to you. Well, the rule in Hollington, let me, just for the assistance of anyone else who's listening, the rule in Hollington is an English rule that says a judgment of another court is an opinion of that court, and therefore generally should not be held as relevant. That's just an aside. And all I'm asking you, in your case, of the judgment that you seem to know very well, is that that was the ground that the public protector relied on, and that's the ground upon which you were that the court found against you and even mulcted you with attorney and client costs. Correct?
It's correct that the court found that the paragraphs that we depended on were not relevant. The judgments were not relevant, and as I've said, I've regarded the judgments as binding between myself and the public protector. What the parliamentary committee does with that is up to the parliamentary committee.
Okay, that's fine. I can live with that. You don't seem to want to. I won't read it for the third time, but it's fine.
May I also point out, it says here that these opinions are also binding on all persons and those organs of state to which they apply.
Yes, that's the Gauteng case. Yes, you can point that out. Yeah, but at least from what you've just now read, you accept that they are called opinions. Okay, those opinions. correct?
Within my understanding is that is within the parameters of a court.
Mr. Pillay, please.
Yeah.
Are they referred to as those opinions? The thing that you just read, does it start with the words, those opinions?
Let me put it this way, Advocate.
Yeah.
Is that how can opinions be binding?
Don't ask me, you're the one who just read it out.
No, what I'm saying is I have never used the word opinion in referring to court judgments. But
Yes.
I don't know enough. It's ultimately it's up to the evidence leader, yourself, and the committee to discuss these things and see are the judgments relevant.
Yes, no, that is true. But that was true about all the other paragraphs you were reading ad nauseum. I'm saying the clear reading of what you have quoted says that those are our opinions of judges.
Opinions that are binding on all persons and those organs of state to which they apply.
Yes.
That is the full sentence.
Yes, but I read it out for you, but you are just refusing to accept the first two words of the thing that you read yourself. But now that's fine. The point I'm simply making is that it is a rule of the law which you should know, not because you are a lawyer, but because it is in a judgment in respect of which you were punished with cost, that what you and Mr. Goddan were trying to do is not allowed, which is to rely on judgments of courts which are opinions as if they were fact. That's just what happened to you. You know, it's not about legal principles. It happened to you. You had to pay punitive costs for that, for making that mistake. Now it looks like you want to make it again. But the whole point of punitive costs is to teach you a lesson. Understand? Do you understand that?
But I understand that, and I really think your client doesn't understand.
You think my client doesn't understand it?
No.
Okay. But okay, that's the same client who raised this issue successfully against you, and you were mulcted with attendant client costs. Which of the two persons do you think doesn't understand that rule between you and her? The one who won or the one who lost that point?
Chair, I want to clarify the issues here. The public protector has also had costs awarded against her. We have had costs awarded against us. And I believe we have learned from what happened to us. That's the point I'm trying to.
Okay, yeah, no, but on this specific point, the one that was being taught a lesson was you, by her, because she raised the issue and you lost the issue. But that's fine. I just wanted to point out to you, and for the benefit of, it looks like the lesson didn't land there. But that's what it is, Mr. Pillay. Judgments of other courts are opinions of that court. And judgments that are pending, you are also wrong there, are suspended by the mere institution of an application for leave to appeal. So they are wrong on both counts, but that's fine. Let's move to something else. You also accept that where were we? We said IGI, KPMG, NPA, Skakane. Right. Number 5, that the Kruan panel also found that it was illegal. The rogue unit was illegal. correct?
They did not find that. They had endorsed the Skakane panel report, and they later said that they were wrong.
That they were sorry.
Yes.
Yes.
And the judge went on to say, Judge Kroon, that the statement was not thought through properly and was in fact incorrect.
Yeah, you've said all that. But at the time, that was the fifth. Let's do it bit by bit, Mr. Pillay. At that time, that was the fifth external body that found that the rogue unit was illegal, correct? Or at least that endorsed the view that it was illegal in this case, correct?
Yes, they did endorse the view.
Yes. Then there was also the opinion of Advocate Brasi SC that pointed in the same direction. So I just don't have it with me. Were you aware of the Brasi opinion?
Much later.
Later, yes. Okay, so that's number 6. Then there was an advocate, I almost said Advocate Manyike, but that's somebody else. There was another advocate who found the same thing, correct? Another panel.
I'm not aware of that. I'm aware of the Trengrove, Advocate Trengrove or Counsel Trengrove had given an opinion to SARS.
Yes. Okay. Yeah, he is an advocate. I think there was one more person, number 8, but I think that's enough. I mean, the point I think is made there. So, as you testified, you said the public protector came at the tail end of this series of negative findings against the rogue unit, correct?
Through your chair, correct.
Thank you. And she was aware at the time that, or rather, she was not aware, for example, that the IGI report would be set aside. So she was working on it at face value, correct?
Through your chair, I think that's one of the issues, is that all the assertions that have favored a particular narrative were accepted without question.
Yes.
Without question, was accepted, as you say, at face value.
Yes.
And that is, in my view, my humble view, that is a problem.
Yes. Now, okay, if you were the public protector or somebody else, and you are faced with 7 or 8 findings by different institutions which are completely unrelated, would you accept that at the very least you should think that there is there's something there?
Chair, I must point out that that narrative was challenged, and there were some reverses. The Sunday Times had withdrawn.
I didn't even count the Sunday Times. Yes, thanks for reminding me. That would be number 9. Yeah.
Yeah, and that's an important one, because Skakane seemed to give some relevance to the Sunday Times reports.
And number 10 would be the City Press then, if we use that series.
Well, my understanding, the City Press report talks about a rogue unit in the SSA.
Okay, just pause there. Just pause there, Mr. Pillay and Advocate Mpofu. I recognize Advocate Bauer.
I just want a clarification a clarification from Mr. Mpofu, whether it's the public protector's version based on multiplicity of reports or media reports of any kind. She's entitled to accept it at face value.
No,
Did you get that, Advocate Mpofu?
No, I got it, but it's just disturbing me for no reason. I'm not under cross-examination here. Mr. Pillay?
Sorry, I'm wanting to ascertain as to what...
No, you can ascertain. We have many months for you to ascertain whatever you want to ascertain. Can I finish?
Advocate Mpofu?
Yes.
Advocate Mpofu?
Yes.
Yeah, no, may I request, because when she was leading evidence, I allowed the opportunity to get clarities and even place certain things on record. I think that consistency is important. She is asking a definite question. I think it's proper that you respond to that and not
I'm
just
never going to do that.
Dismiss it.
I'm never going to do that. I'm not going to answer her question. I've given the clarification that I'm busy with cross-examination. If she wants to understand anything, she'll understand it when we give her a statement.
Let's do this.
Mr. Pillay?
Because if no, before you go to Mr. Pillay, not only her, if there are going to be members here who are going to ask a question and clarifications, I expect that there be a response to that. In a form of an answer. If you're not able to answer, you'll indicate that, but I can never accept you saying you're going to answer that. I don't think it helps this process.
Chairperson, yes, you know very well I've been responding. If there's a reasonable question, I respond to it. But I'm not going to, in the middle of my cross-examination, be answering questions about versions and whatnot from anybody. So, but if it's a question that is a clarification question, as you are saying, then of course we deal with them in the usual way. But I'm not going to right now, be telling you what the version of the public protector is or is not on a particular point. I mean, you allow me to, you're just allowing me to be abused.
I'm not.
You are.
Let me assist because when I allowed you during the leading of evidence.
Yeah, that was different.
No, I'm on this. I'm speaking, Advocate Mpofu.
You see now.
I'm speaking.
Chairperson.
But I can't allow my cross-examination to be.
Advocate Mpofu, please switch off your mic, Honorable Milam. Advocate Mpofu, I am addressing you, and I don't expect you to be throwing hands in the inquiry. Please, I want you to really pull back on what you're doing. All I'm indicating here, that's how the inquiry has been running. It's going to continue doing that. I will never not allow the evidence leader, yourself, or any member here not to have an opportunity to intervene on a particular issue that they want clarity on or want to ask a question. So I'm not going to change that. So I'm asking you, because if your point you're making, because you better if you say, maybe you're not ready to respond to this issue at this point, but you will respond with that something else in terms of what evidence the public protector will place. But it's not helpful to just say, you're never going to do this. It doesn't have this process.
But I've just said that. But I said exactly what you are. I said exactly. If you play the recording, I've said what you are advising me to do. So thank you for your advice, but I don't need it because I've just done exactly that.
Okay, let's proceed. But I'm going to be watching this. I need responses when clarities are sought.
Yeah, and I, as you know, for the past 3 weeks, I give responses when proper clarities are sought. But I'm not going to be forced to answer.
Just pause before you proceed, Honorable Nodada.
Thank you so much, Chair. I just want to come in here as a concern, Chair. Chair, we're running a process here. There are directives. We've requested that we all respect one another when we do speak. I think the language used by Advocate Mpofu is completely out of line.
Please.
And there can't be statements that are made that I will never do this and whatever the case may be. There are directives that guide us here. Let's please calm down, respond to each other respectfully. What has been requested is not the first time it's been requested. It's been done previously, and it's been responded to by Advocate Mpofu and the legal team of the Public Protector on whether that's the version of the Public Protector or not. So I don't see why we should be up in arms. Let's please just calm down, respect this process, because it does apply to all of us, and there are directives that guide us to do that, and not throw statements that can, derail this process and make it be something that it's not. Thanks, Chair.
Okay, Chairperson.
Thank you, Honorable Nodada. As you allow you to proceed, Advocate Mpofu, on this issue, it's a simple response of yes or no, and you proceed.
No, I'm never going to do that.
Hello?
I'm not going to respond to a question about versions when I'm busy with cross-examination. I will put my version when I put it. If you want to kick me out, you can kick me out. I'm never going to do that. Let me say it slowly. I am not going to do it.
Now, Advocate Mpofu, you've been doing it. We've been doing
questions differ, but I've been doing it for 3 weeks. When the question is reasonable, when it's reasonable,
I want you to come down. It's an important process that we're dealing with here, and I do need that indication from you as a chair, because there's no point in us just proceeding when we're not able to hear each other, because then it defies the importance of this hearing. If you are saying you would want to come back to that issue and give a response, I will allow you to do that, but I'm not going to accept an answer that says you're never going to do it.
Okay, yeah, maybe that's too broad. I'm never going to do it right now. I agree with you. I will do it when it's suitable to do it. Yeah. Sorry about that.
Okay, I will keep that. I will remind you. Let's proceed.
Thank you, Chair. Right, Mr. Pillay. Sorry, before that interruption, I was saying that I think that my question was, and I was trying to put it at the lowest level, that if you were in the shoes of the public protector and you were faced with all these 8 or 9, whatever number, views that the rogue unit, the so-called rogue unit, was illegal, could you be possibly forgiven for thinking there must be something in this? And I was putting it at that kind of level deliberately. I'm not saying you say, well, it must be definitely beyond doubt, but just to think, for a reasonable person in her shoes, to think there must be something in this thing if all these 8 or so organizations that are different have found it all to be illegal. Would you at least accept that, just at that level?
Chair, as I say, I'm not a lawyer. I know something about investigations.
Mm-hmm.
What I know, what we've always done, and I cannot speak for the public protector. What we've always done is before proceeding to an investigation, first inquire into the allegations. Understand the allegations, who's making the allegations, what is it about? Is it vague? Is it specific? The who, what, where, whence, and to the extent that when we're looking at reports that are done, where people given the opportunity, where people heard, where all of those things done properly. So that is not it's not an investigation itself. That is to verify the allegation that this is a serious allegation that needs to be dealt with. That is what I would do.
Yes. No, I accept that, Mr. Pillay. I really do. All I'm saying to you, remember here, we're not really about scrutinizing the ins and outs or the wherewithal of these 8 or 9 institutions. I'm asking you a very simple question. What's here, gathered here, to assess the conduct of the public protector? You understand that? You volunteered as a member of the public to assist in that process. Are we together?
Yeah.
Yeah. Now, so that's really our only business here. Now, I'm saying now, put yourself in her shoes so that the honorable members, when they have to assess her conduct or otherwise, must be able to do the same thing. I'm saying put yourself in her shoes, and here you are doing an investigation with all the qualifications that you've correctly put. You know, we're all human. You know that there are 8 or 9 different agencies of varying degrees that have found that this thing is illegal. All I'm saying is that at a human level, are you entitled to say there must be something in this? If this one, and the KPMG and Kakane appointed by Mr. Pillay and the NPA and so on, all of them, without sitting in one meeting, find that this thing is illegal. There must be something in it. If you're not prepared to concede that much, you're not. But that's what I'm putting to you.
So Chair, let me answer this firstly by way of an analogy, and then later I would give you my view. Mm-hmm. When I was working in intelligence, there were a number of reports from police crime intelligence, from national, from different divisions in national intelligence, right, to say there's a conspiracy to overthrow the ANC government. Mm-hmm. The people who were involved in this is Big Botha, blah, blah, blah. It named a lot of people. And there were all of these reports coming in. And Minister Nhlanhla at that stage said, look, this is very serious. Mm-hmm. All of these things are saying similar things. Mm-hmm. So at that stage, a committee was set up, a commission, but it's an internal commission. Mm-hmm. And it was chaired by Advocate Vusi Pikole. Mm-hmm. I was fortunate to be chosen as a member of that. Mm-hmm. And we went into all of those things by doing the first level checking. Who said this? Who's this? Who's the source of the information? How was this obtained, etc., etc. The people who are making statements, were they cautioned, all of those things. We did all of those things. Yeah. We found at the end of it that all of it arose from one policeman in the Free State. He was the source of all of this information. And he had the Minister Nhlanhla and many, many other people running around for months on end on this. And I remember that when we presented the final report, it started with saying, one day in Bethlehem, because it was really Bethlehem, playing on the biblical references. Yeah. And I can tell you that the political principals were not happy with that answer. They really believe that there is a conspiracy.
Yes. No, fair. That's exactly I get your point, Mr. Pillay. Sorry to cut you. That's exactly what I'm asking you. That those political principles that you are dealing with, the whole thing could have been just nonsense. But I'm saying those political principles could be forgiven for taking it seriously simply because of the number of voices that seemingly were unrelated, saying the same thing. So you and I are making the same point.
No.
So you're saying that they were crazy?
No, through the chair, I think it is easy for political principles to fall into that trap. Public servants, people in public administration should not be falling into those traps. In fact, we are the ones who should be helping the politicians.
I see. So they're not human beings, there's public servant. So they don't, if you are a public servant and 8 or 9 people in the building say there's a fire, because you are not a politician, you must dismiss them. What is that?
Through you, Chair, that is not what I'm saying. The point we have made repeatedly is that the public protector has chosen uncritically to accept allegations about us, and she has chosen to discard almost anything that we have said. That's the point we're making.
No. All right. I'll move on. I don't think you understand what I'm saying. I'm talking about before that, before she makes any finding, before all that. I'm just saying when she gets a complaint, and part of the material before her is that there are 8 or 9 agencies from Limpopo and wherever and Eastern Cape and who uncoordinated in some one gathering have found the same thing. Is she at a human level entitled or not to think there must be something in this? Because we're not starting from scratch. There are other people who have found this way. I mean, it's such a simple notion, but if you're not prepared to concede that, then that's fine. Let's move on to something else.
So Mr. Chair, I just also want to point out there's a timeline, and I can't remember the timeline. But some of these things began to fall before and during the process that the public protector was working on these things. And she refused to pay any attention to them.
They fell. What do you mean by that?
They were withdrawn. I mean, some of these reports were withdrawn, and the public protector took no account of that.
Was this Kakane report ever withdrawn?
Mr. Chair, my understanding is that one could not go to court to set it aside. My understanding is that under the new commissioner in SARS, they have said they place no reliance on it.
No, Mr. Pillay, please, we'll never finish if you don't listen to the question. Was the Sikakane report ever withdrawn, yes or no?
My understanding is that it's an opinion.
Yes,
and SARS says that it sets no store by that opinion.
Mr. Pillay, I'm asking you for the last time. Let's assume it's an opinion or a work of fiction. I'm saying to you, was the Skakane report ever withdrawn, yes or no, to your knowledge?
My understanding is that it's not necessary to withdraw it. It is an opinion.
I take it that you are refusing to answer that simple question. I've asked it 3 times and I'm not going to ask it again. The reason I'm singling out the Sikakane opinion, rather panel report, is because it was appointed by you, Mr. Pillay. So surely it can't fall into this category of the Bethlehem situation.
Mr. Chairman, I must point out that there was terms of reference given to Advocate Skakane, and he changed the terms of reference to fix his focus on on a unit in SARS.
Yes,
That was his choice.
yes. And having exercised that choice, which is wrong and what have you, was his report ever withdrawn?
My understanding is that it is not necessary to withdraw it. And my understanding is that the judgments have pronounced that it's actually wrong in law and in fact in many instances.
And those judgments might be reversed on appeal.
That is possible.
Yes, thank you. No, that's fine. All right, now we'll argue it at the end. Now, you also testified about the IGI report specifically. And you were taken to paragraph 113, I think. If you can just quickly go there. Starts at 112. Just want to show you some of the dangers of relying blindly on court judgments or the opinions of courts. Are we there? Do you have the hard copy version, Mr. Pillay?
No, I don't.
Okay, so let's wait. Okay, thanks. Okay, anyway, while just so that we save time, the passage that you were taken to, some of the passages, remember that the public protector was found to have been biased and all sorts of things like that, on the basis that she had claimed that she had not seen the IGI report in the report. In her report, I'm sure you've heard. Yeah. Did you watch the evidence of Mr. Van Lochenbeck?
Through your chair, yes, I did.
Yes. Okay. So that's good. So you know some of what's coming. So I'm saying one of the issues which Mr. Van Lochenbeck and I debated was this issue. Do you also associate yourself with his evidence that the public protector had emphatically stated in the report that she had not seen the IGI report?
Chair, my understanding is that it's the judgment says that uses the word emphatically.
No, it's not. The judgment used the word explicitly. Mr. Van Lochenbeck used the word emphatically, which basically means the same thing.
I think I used the word coyly denied.
Yeah, so you don't agree with Mr. Van Lochenbeck that it was emphatically put in the report that she had not seen it?
At this stage, I can't remember too well, but I had a different view at that time and I expressed it.
A different view to Mr. Van Lochenbeck?
The different view is expressed in the affidavit. We say it's a coy denial.
No, Mr. Pillay, please listen to the question. Do you agree or disagree with Mr. Van Lochenbeck when he says the public protector in her report emphatically stated that she had not seen the IGI report?
I have a different view. And it's
that's the same thing as disagreeing. What's your problem? You can say you disagree with Mr. Van Lochenbeck. It's fine. He's not going to do anything to you.
Advocate Mpofu, he has a different view.
Yes, Chair. I'm entitled to ask him to answer my question squarely. I asked him a simple question: does he agree or disagree? I mean, I'm not a linguist. I don't have to go to some dictionary to work out his answers. Okay, Mr. Pillay, from that, I would assume, therefore, you disagree with Mr. Van Lochenberg, correct?
You can assume so.
And so can the committee, correct?
It may assume so.
Yes, thank you. And with that answer, I can also then assume that you differ with these three charges. Judge Bakwa, I think, the former public protector, Judge Windel and Judge Basson, when they say the public protector relies on this report, I'm reading it 113, despite explicitly stating that she has not seen the report. You also would disagree with that, correct?
Chair, I've said I did not use the word explicitly stated in my affidavit.
Yeah, hence I'm asking. If you had used that word, I would not be asking you this question.
Yes.
I'm asking exactly because you seem to disagree with it. Yeah. Thank you. Sorry to interrupt you.
Yeah. So there is a judgment, and the judges have expressed it in a particular way, and I'm sure that the public protector, in her appeal, is going to deal with that matter.
No, well, it's unlikely that the Constitutional Court will grant her appeal. I'm just saying to you, whatever happens in the appeal, as we sit now, do you agree or disagree with that sentence of the three charges? You've already, it's the same as, to give you a hint, it's the same as Mr. Van Lochenberg, with whom you've already disagreed. You know, in the quiz on radio, they give you a hint here. Yeah. Oh, they say, ask a friend.
But look, Mr. Chair, through the chair, is that I understand that Advocate Mpofu disagrees with this.
No, I don't.
No, and
I have no view.
And that is his view. I stated my view. I have placed it in an affidavit. There is a particular judgment. It's worded in a particular way. It is up to the public protector to challenge that. And
yes.
You may find errors in it. You may not find any errors in it. So
okay. No, that's fine, Mr. Pillay. I'm afraid I'm going to sit on this one until you give me an answer. I'm saying to you, this should be simple. It shouldn't take us this long. There's a statement by Mr. Van Lochenberg, which you've said you disagree with. There's a statement, exactly the same statement, word explicitly, emphatically in this context means the same thing, from the three charges. But now you're having difficulty with saying you disagree with this one. I mean, does that make sense even to you?
So through the chair, I know what the advocate is trying to do. He's trying to pick on one or two particular instances and to generalize from that.
Right.
I am saying that the judgment differs from what we put in our affidavit, and I recognize that. And I'm sure that the public protector is going to raise that issue. So that's but I think that the real key issue that concerned us is that the public protector had a view on that report. We didn't have a copy of the report.
Now that much, unlike you, I'll concede that part. You did not have that report, but I was asking you something different. Sorry, Mr. Pillay.
And the second thing that I want to say is that the IGI put nothing before us. She didn't call me to an interview. She says she called me to an interview, and that's not true. She didn't. She came to our offices. We had a general discussion on how we should cooperate with what we thought was a genuine inquiry. And insofar as my matters are concerned, that's for me, when it comes to the OIG report, are for me the very important things. Thank you, Chair.
Thank you, Mr. Pillay. Thank you, Adv Mpofu. If you may pause there, we'll take a break for lunch and be back at 2.
Okay,
Recording
thank you, Chairperson. Thank you.
Our lunch will be 15 minutes late.